It's been there from the very beginning. We have this system of law only because of the nature of a creature who can make laws in the first place.
Welcome back to another episode of Mic'd Up. I'm your host, David Gordon, and it's my distinct honor to introduce to you Professor Hadley Arkes, who is Professor Emeritus at Amherst College, and he's the founder of the James Wilson Institute in Washington, D.C., which focuses on natural law and American government. Recently, Professor Arkes has released a book with Regnery Press called Mere Natural Law, and in it, Professor Arkes covers the intersection of the natural law with American jurisprudence and American law in general. And that is the topic for our discussion today. Dr. Arkes, thanks so much for being with us. How are you doing?
Thanks for having me in, David.
Oh, it's our pleasure. I want to jump right in and have you do me the kindness of kind of defining for our audience what exactly is natural law. In a lot of Catholic circles and academic circles, this is a common term, but just on the man on the street might not be familiar with the terminology.
But it's the man on the street who knows more about it than has as good a sense of it as many lawyers, most lawyers. The natural law is really those principles of rights and wrongs that were there before the constitutional laws, the principles that the founders drew upon as they framed the Constitution, and the principles that would be there even if there were no Constitution. Just as John Quincy Adams would say that right to petition the government is simply implicit in the idea of a free government. It would be there even if it weren't mentioned in the First Amendment. It would be there even if there were no First Amendment. It would be there even if there were no Constitution. I call this mere natural law because I'm drawing on that C.S. Lewis, Mere Christianity, about those things that are so simple that they're accessible to ordinary folk and accessible even to children. So we're saying that we're not offering theories. The natural law is not something hovering in the sky or good sentiments. But it involves those precepts of common sense that the ordinary person has to know before he can start trafficking in theories. So as Thomas Reid, the great Scots philosopher on common sense, would point out that before the average man would start bantering with David Hume about the meaning of causation, he knows his own active powers to cause acts to happen. The ordinary man doesn't know about the law of contradiction. He knows when he's getting conflicting stories. And he may have a stake in knowing the truth, the true account rather than the false account. So he has an awareness of standards of judgment. So it's that which we're bringing in, those kinds of principles accessible to the common man, the ordinary man. That not only does he know, but he has to know in order to get on just with the business of life. That's where we find the anchor of this thing. And that's where the American founders understood it. They took their guide from the same grounds of natural law. They understood, for example, the ordinary man would understand. If you ask the ordinary man, if you're told that Jones, being prosecuted for burglary, was in intensive care following surgery at the time the crime was committed, the average man, I think, would wonder, why are you prosecuting it? That is, the average man would understand what Reid and Kant and others took as truly the first principle of all moral and legal judgment, which is you don't cast judgments of praise or blame on people for acts they were powerless to effect. And so we say, no, we don't hold people blameworthy for acts they were powerless to effect. That simple point that any ordinary man understands threads through our laws. And part of the argument here is that that's what we're dealing with. It's not over our laws. It's not something that the judge has to call upon. It's always there. It's always there. And there's always a need in trying to apply the law, the statutes, to appeal again to those underlying principles in order to make sense of what is before us. And how do we understand this case?
So is it fair to say that the natural law is man's ability to grasp truth, to arrive
Yes.
at a clear understanding of reality?
Well, Aristotle says animals can emit sounds to indicate pleasure or pain, but only human beings, by nature, can give attending to argument. We're the only creatures who have arguments. Arguments imply you have some standards of judging true or false arguments. We have access to reason. Of course, when we're talking about the nature of human beings, we're talking creatures who can give and understand reasons over matters in right and wrong. The only kind of creature who can make a commitment and can be expected to honor that commitment, honor the obligation, even when it cuts against his own interests. Well, once you've got a creature like that, the point is, as Aristotle tells us, law springs exactly solely from a creature of that time. There's no surprise here. Of course, the notion of nature and natural law is in place, is the very ground of having a law.
So would you say that the Constitution, specifically something like the Bill of Rights, is an outgrowth of the natural law? Like it's the next logical step from the basic precept of the natural law?
No, it introduced a confusion about the natural law. Because people forget that there was a serious argument about the Bill of Rights from the beginning. And the reservations about the Bill of Rights didn't come from people who were reserved about rights, but are concerned that we were misinstructing the American people about the ground of their rights. And so you find people saying, those rights I have through the First Amendment. Are you suggesting that the absence of that amendment, you wouldn't have the right to speak, to engage in associations? Remember, James Wilson, our premier minds among the American founders, said, we didn't bring forth this government for the sake of inventing new rights, but for the sake of securing and enforcing those rights we had by nature. The original people concerned about the Bill of Rights were saying, well, do you really doubt that in a free government, you don't have a presumptive right to speak, to form associations, to walk down the street? The presumption is that you had to act as a moral agent, someone who can reason about matters of right and wrong. You have a presumptive claim to all dimensions of your freedom, and the burden would fall to the government to establish the ground of justification for restricting you in any of your freedom.
And now that is that why you put such an emphasis, put such a premium on the consent of the governed? Or how does that really play into our constitutional system and the legitimacy of the American government?
It is the ground. It's the ground of the whole thing. As you know, my friend Scalia took his cue from the positive law that is posited and enacted. But who has the authority to make those positive laws in the first place? Lincoln, in his first inaugural address, explained that the rule of a majority under league moral and constitutional strengths, a majority that understands it's not free to decide just anything, that is the only operational form of government by the consent. Well, why do you have government by the consent of the governed? You have to go back to this antecedent point to explain who is it who makes the positive? What is the rightful government in making positive law for human beings? It goes back to the anchoring principle, the first principle, the proposition, as Lincoln called it, the American machine, which was all men are created equal, meaning no man is by nature the ruler of other men. In the way it was understood, God is by nature the ruler of men, and men are by nature the ruler of horses and dogs. And so if you find anywhere in the world where some human beings are ruling over others, that situation can't arise from nature. It must arise from convention, because people have consented to be governed. So that original understanding, Barack Obama was convinced that all men are created equal just isn't an absolute truth. There are no absolute truths. Lincoln thought it was a truth. James Madison thought it was an absolute truth, because it ran down to those original understanding of the nature that separates the divine from the human, from the superhuman and the subhuman, that no man was by nature the ruler of others, the way that men were by nature the rule of dogs and horses.
But doesn't the power to govern come from God, like Leo the 13th, who is over your left shoulder as we speak, has penned in not just one, but a few encyclicals?
Well, yeah, well, as James Wilson said, government is one of the best gifts of God, okay, to man. Well, you have government only because you have a nature. The nature stems from a creator. The Declaration of the talks about that creator who endowed us with rights, that creator who imparted to us the nature of rational creatures who can frame propositions that others can be invited to respect and command the respect of others. So we'd say the whole thing has its origin with that author of the laws of nature. Now, Aquinas said that the divine law we knew through revelation, but the natural law we know through that reason that is accessible to human beings as human beings. Now, the church, as you know, what it makes, its argument on abortion and its defense of the child of the womb never appeals to faith. It always appeals to that natural law. We say, so why is that child in the womb less than a human? Doesn't speak yet? Well, neither do deaf mutes. Doesn't have arms or legs. Well, other people are born with arms or legs without losing their standing as human beings to receive the protections of the law. In other words, there's no principled ground on which you can deny the human standing of the child without denying the human standing of many people walking about. Well, see, this is the way the church is. Yes, God has given us this capacity for reason, for framing the kinds of propositions that can guide others in this law, give us the means of deliberating about these things, but also the thing that the Christian perspective adds, that you might find in Greece, is that problem I put to you just before we went on. Why do we consider that biped who conjugates verb as a rights-bearing being? It runs down to Lincoln saying, no one made in the graven image was sent into this world to be imbruted, to be treated as a nothing. Lincoln recalled those slaves who did not throw in with John Brown at the time of his uprising. And he said, as ignorant as they were, they had the wit to see that the schemes of this crazy white man were not going to conduce to their well-being. They may not be educated, but they were moral agents, as we'd say. These are creatures who had the wit to reason about their own well-being and the well-being of others. They didn't deserve simply to be annexed to the purpose of other people without their consent. Well, how do you get there? Except you understand, first, what is different about these beings who can give and understand reasons, have some reasons for that, reasons for the acts, have some sense of a good that they're striving for, but also gives them this standing which makes us respect them as rights-bearing beings. Now that comes more readily from a Christian Jewish perspective.
So under the framework, and I think this is one of the main tensions in the book, and this is one of the things that really pops out as you read through this, it seems to be that if we're going to have this natural law theory of jurisprudence, and I think
not a theory, David. Okay, it's not a theory.
Sure. If we're going to be incorporating natural law into American jurisprudence, it seems that the Constitution and the positive law are unnecessary. Is that your contention?
No, of course not. It's always been necessary. The natural law must always give rise to the positive law to be converted into regulations consistent with the natural law, governed by the consent of the government. You can have all kinds of different political orders. You can have a constitutional monarchy. You can have parliament with one house, two houses. We see signs saying 35 mph and 65 miles per hour. Those signs don't have moral significance, but behind them is, as Kant would say, the underlying law that tells you why you would be warranted in having law in the first place. Behind it is a principle that tells us why we'd be justified in restraining the freedom of people to drive at speeds that put innocent life at hazard, including their own. But then we have to make a transition, right, David, from that principle, that natural law principle, to some regulation that applies the principle to the circumstances before us. 35 miles an hour on that winding road, 70 on the open road. It's always understood that the natural law gives us the underlying principles, and we still have to make a transition with some practical regular. In the case of a constitution, we do need a constitution that gives us a structure. Now, it matters profoundly to me to know things like, whom will the military obey if a president dies in office? May a state make its territory available as a military naval base to a foreign power? I'd like to know things like that. Those are matters of structure. Now, you can do things different ways with the principles of natural law, but there's still a need to make the transition from the underlying principles. Whatever government we have, it can't be one that holds people punishable for acts they were powerless to effect, right?
Sure. No, of course, and there has to be that principle of justice. But then, is it your contention that something like the Bill of Rights and this anti-federalist, federalist debate that goes back to the birth of the nation, really, and even things where we're conferring somewhat positive rights on protected classes like the 1964 Civil Rights Act, are things like that in and of themselves redundant under a natural law framework?
Well, no, you still have to make a connection. You have to recognize wrongs that took us a while, doesn't it, to recognize that harms that could be inflicted through speech, that by spreading false things about a person, you could ruin his reputation, ruin his business, We had cases on that before we had statutes on that, These questions arise. And the whole problem of race and slavery, racial discrimination, the question is, in dealing with them, we have to call upon those deeper principles. Why, as linked to, why is this black man less of a human being than he's darker than you? Then you think the lighter skin have the right to rule the darker? Beware, the next white man who comes along with a complexion lighter than yours will enslave you. In other words, the deep principles are there. The problems arise before us, and we have to try to we have to figure out how we live our lives together according to terms that can be regarded by and large as just. New questions may arise, new problems may arise, new ways of defaming people using social media. Okay, and when they do, we have to just go back to the underlying principles about what are the. See, you mentioned the Bill of Rights. Now, John Marshall, great John Marshall, Chief Justice, said, anyone who publishes a libel in this country may be sued or indicted. He could be sued for personal damages or indicted for sort of stimulating stirring up hatred against religious and racial minorities. He said that even when there's a Bill of Rights, the First Amendment, he didn't assume, even with the Bill of Rights, he didn't assume that any act of speech was by nature innocent. Speech could be used as a device to inflict harms as well as anything else. So when you say it's not the matter of incorporating the natural law, it's been there from the very beginning. We have this system of law only because of the nature of a creature who can make laws in the first place, who can reason about matters of right and wrong. And there's the classic understanding was, say, if you come to the judgment, it is truly wrong for parents to torture their children. You don't deal with it by offering people tax incentives to stop. If you're saying that something's wrong, you mean it's wrong for the moral voice, for anyone to everyone to do. In that case, we're saying if it's wrong for parents to torture their children, we say it's wrong for anyone. We'd be justified in forbidding that torture to whom? To anyone. with the force of law. That is the classic connection between the logic of morals and the logic of law. That's how we have law. So you say, does it incorporate? It has been there from the very beginning. It forms the very ground on which we understand what we mean by this thing called a law.
So then, really, a focus on right and wrong is the linchpin. You're going to bring this into jurisprudence and have judges essentially applying the moral law.
They've never been away from it. They're doing it all the time. You do it every day. I said, look, I see a youngster. Well, look, let me put it. A couple of years ago, my neighbors and I in our apartment building were put out on the grounds as the fire department was fighting a fire. Our liberty was obviously being restricted, our liberty to walk into our own apartments. Nobody thought that night that his rights or his constitutional rights were being violated. Well, how did they frame the problem? They understood that the restrictions were animated by the purpose of protecting our lives. Therefore, they understood that those restrictions on our freedom were just, justified, rightful. This is the way ordinary people reason about these things. There's nothing esoteric here. I see a youngster on Connecticut Avenue about to go into the subway with his bicycle, and I say, "You can do that?" And he says, "Yes, but not during rush hours." He understands. It'd be unreasonable for him to take that down and take up the space of 2 or 3 people. In other words, he understands why it's justified to restrain his liberty to bring that bicycle down. In other words, it's as I say, there's nothing esoteric here. Ordinary people make these judgments every day. They're moral judgments. Judgments about the things are generally right or wrong, justified or unjustified. Nothing arcane here.
But if we have conservative judges and justices applying the natural law, then doesn't this give rise to the opportunity for abuse in that we're going to get liberal justices that start applying the unnatural law and legislating from the bench as they're so prone to do? Isn't this really opening ourselves up to abuse in American law?
Let's get careless. That people are going to make mistakes in their moral reasoning, great revelation. What is the corrective to it? Abandon moral reasoning altogether. Don't give anybody the sliver. Or is the proper correction? If you think there's something specious and false about this, well, counter it. Explain where they have it wrong. Where is it false? This strange reflex of conservatives. You see, people move outside the text to invoke those principles that were there before the text. Oh, God, if we do that, look what liberals are going to do. And we'll show them. We're going to be in special genius here. We're going to avoid moral reasoning altogether. So when we face the question of abortion, we will not reach the question of whether that the human standing of the child in the womb will steer around all those questions of moral substance. That's what we get into.
But if we give justices a green light to moralize from the bench, which in theory, I really do support, obviously. I'm all for bringing the natural law into jurisprudence. But if we give them this license to do that, then that just seems ripe for abuse, and it becomes a question of power. Who gets on the bench? Who gets appointed by what president? And as you know, liberal presidents, the Democrats, bat 1,000 when it comes to placing activist judges. And, conservative presidents, Republicans, tend to bat around 500 to 600 when placing judges. I mean, you mentioned in the book, you name drop the Warren Court and also the Burger Court, both of whom were appointed by Republican presidents.
Well, that's right. But again, am I doing something dangerous when we're licensing ordinary people to make judgments about whether it was justified or unjustified to remove them from their apartment buildings? If they were removed there because of a prank by the police force, they would have found it a wrongful restriction of freedom. It's implicit in everything they do. There is no way to shed the need to engage in an argument of whether this law is justified or unjustified. That's what this business is about. Moral judgment is at the very heart of the law, to explain when we're making a law, we're displacing the personal freedom of people, removing their private choice, we do something like that, we're obliged to say something more like that. Most of us want to do it this way. We're obliged to show some ground that establishes the rightness of that law, even for people who disagree with it. Now, once again, why do you assume because you appoint them, you say you're appointing them, but that doesn't mean everything they do is going to be. We've had some awful decisions made by Republican judges, even lately, about transgenderism. Well, the corrective to that, the only corrective can be to correct it, to argue against it, to start cutting that back. I hope that Mr. Gorsuch will start recognizing the mistakes he made in the Buster case on transgenderism. And if a case comes up about transgenders in bathrooms and locker rooms, that he'll find the grounds for finding something wrong with that. We may plausibly restrict the freedom of transgendered males to transgendered women to enter female bathrooms. Again, but what are we doing? You're not going to revoke his appointment. Yes, the people you appoint, you think are conservatives, can make serious mistakes. I think they've made a serious mistake in the Dobbs case. They gave us the result. They overturned Roe versus Wade. But Roe versus Wade did more than give us a decision. It changed the culture. It converted abortion from something abhorred, avoided, condemned, into something approved, celebrated, promoted. The decision in the Dobbs case did nothing to offset that, right?
Sure.
So but the point is, you have Republicans appointed, really good men. A couple of them, I have friends among them, and then we find ourselves dissatisfied, finding serious flaws in what we think they've done. And what's the recourse? We argue with them, right? We give them reasons. We try to offer a better perspective, a better understanding, a better argument.
Well, of course, law is a science unto itself, and it has its own processes, and it has obviously case law and positive statutory law. Things like that need to be applied, at least under the current legal framework. But it sounds like you're saying, instead of, when the justices overturned Roe, instead of going through and saying, well, in Roe they did a faulty substantive due process analysis because this right was never protected and seen as integral to fundamental American freedom going back to the founding. Instead of doing that, they should have just said, well, abortion is murder and there's no right to murder your children. Do I have that right? I mean, and again, I'm all for that, but it would be a complete shift from the legal science as we know it today in American law.
You've just given a notion of legal science utterly detached from the moral ground of that. It sounds like Justice Holmes saying we have to purge every word of moral significance altogether. Look at the colored way you put that. Murder is wrong. A murder is an unjustified taking of a human life, right? So the task is to show it's an unjustified taking of human life. 50 years ago, the lawyers from Roe and from Texas drew on the most updated findings of embryology to establish for the court that child in the womb has never been anything other than human from its very first moments. It received its nourishment from its mother, but has never been merely a part of the mother's body. The court, presented with that evidence in 7.17, could do what they've ordinarily done and say, the state has shown a compelling reason to treat those those offspring in the womb as real human beings who deserve the protection of the law. And yes, we sustain those laws, those laws in Texas that cast protections of the law on unborn children, as the laws have always cast those protections among unborn children. Nothing novel there. What was novel is trying suddenly removing that, pretending this late in the game we don't know what a human being is. So I don't understand why this is so inscrutable to you. It's quite open for the judges to come back and say, look at the mistake made in 1973. It's not simply that there was no deep right to abortion in our history. What was involved here with the evidence of they were dealing with the taking of a human life, that the laws on homicide have ever been indifferent to the size and weight and age of the victim. The murder of an older person is not a worse murder than the murder of a child. There's nothing esoteric here for them to do, David. And it's not. It does not involve any great wrenching of the legal or constitutional order. And that to think that it must be we've been flooded with theories that tell us what is that the wrong of the case was abortion is nowhere mentioned in the Constitution. Well, the right to marriage was not mentioned in the Constitution. When the court struck down those laws that barred interracial marriage, and as Jerry Bradley, my friend at Notre Dame, has pointed out, the federal government had ample reason to deal with the matter of abortion in military hospitals, in the territories, in diplomatic outposts abroad. There's no way that the federal government would avoid involvement with abortion. So it can't. The wrong of the case could not be that abortion was not mentioned in the Constitution. The wrong of the case was that the court withdrew the protections of the law from what the evidence told us so plainly was a small human being from his first moment.
Well, so it sounds like to me what you're really advocating for is courts to have moral courage to say what the truth is. And that's something that American courts have been really loath to do. They've had this seemingly false notion of judicial restraint where it's, I'm not going to weigh in on things wherever there is some ostensible scientific debate, that's beyond us. And, that's what the court said in Roe, of course, which is, the philosophers, the theologians, the scientists haven't fully settled on, when life begins, whether it begins at conception. So we, the court, don't want to wade into this sticky issue. It seems like whenever there's a plurality of opinions on something that is fact-based, the court prescinds from actually dealing with those issues. Are you just calling for the courts to have greater moral courage? Is that fair to say?
We're asking for moral coherence. And what we're asking us to do is, you must not be unwilling to recognize the objective truth that stands here. With Bostock on the transgender, we reached a decision that if Andrew Stevens thinks he is a woman, then everybody else is bound to respect that judgment. And if they don't respect it, they're going to put themselves or their employers at peril. Now the conservative judges can look and see, what did sexual discrimination mean in 1964? But beyond the dictionaries, the question is, what sex is? As the Congregation for the Doctrine of Faith once explained, there's not always been an Italy. There's not always been a Hungary. But as long as there are human beings, there must be males and females. That is the very purpose or the telos of sex. And you go back to say, look, it is not a matter of what the statute said in 1964. The fact of the matter is, this is what you're born. You weren't assigned this sex at birth. All the marks in you, your organs, the way you are constituted, mark you as a male or female. Now, what seems to be, you've touched something that seems to be curious, what a curious convention settled among the conservative judges. They're reluctant to move beyond their frame to recognize the truth that stands before them, whether it's the meaning of sex or who is the victim. What is the nature of that being who's being destroyed, who's being poisoned or dismembered in this surgery? Are you saying that judges cannot face that question as they face the question of whether we're sustaining or knocking down statutes on abortion? What is it about? So to tell us, it's not say we have more courage. Sometimes it means to say to have the courage to look at the situation seriously, not blind yourself to what the truth that stands before you. And I guess one of the curious things is how conservative jurisprudence has talked itself into the notion that somehow we have to work within these lines and we may not go beyond the text, even though the American founders would have to go beyond the text to explain their judgment. And as I wrote a book called Beyond the Constitution, trying to show how judges, even our own time, have been compelled to go beyond the Constitution to those principles that were there earlier in order to explain how they apply the Constitution sensibly.
Sure,
To
and
this,
you quote John Marshall in Mere Natural Law when he's, in one of his early opinions, obviously first Chief Justice of the United States Supreme Court, where he's like, well, I don't even think it's necessary, and I'm paraphrasing here, to go through and explain this, but I'm going to explain this, for your benefit. Some of these things, it seems like they thought that the inference one could draw from the natural law, from reason, was it was self-explanatory.
he said, let me remind you where this is all based. I can't, in order to give a demonstration, there are things you have to know before you get into a demonstration, like the law of contradiction. If you don't understand that, it can't be demonstrated to you in the form of an experiment. It's one of those things you have to know before you step into the experiment. And you saw me quoting Alexander Hamilton saying, in all disquisitions, everyone things begin with certain primary truths from which all subsequent reasonings must depend. There's things we grasp per se nota, like the law of contradiction, as true in themselves. They reveal their own internal evidence, and such as makes no sense to hold people responsible for acts they were powerless to effect. It's things of that kind. So what was interesting about the founders, about people like Marshall, is that it's at the very beginning. They understood that they're supposed to be acting as teachers to remind people of the grounds on which this whole thing was built. So it was a remarkable knack of tracing their judgments back. Remember, Alexander Hamilton, you're a lawyer, you've read the Federalist Papers. Alexander Hamilton says, in Federalist 78, we assume that every later statute overrides the earlier one. But that's not what we assume with the Constitution. The Constitution coming earlier must be able to override a statute coming later, or else it loses its function as a control on the legislative power. And then he asks, well, how do we know that rule? That rule is absolutely critical to it. How do we know it? It's not in the positive law. It wasn't spelled out of the Constitution.
Supremacy clause, I suppose one would say.
Yeah, he says, no, it's it's just why the ground law, the Constitution is the ground law, the law that tells you how you get laws. It's first in that respect. Explain that. And that's why that must be able to overrule a statute coming later if it's not consistent with the fundamental principles of the text. I mean, how do we know we have a Congress? It's in the Constitution, right? It has two chambers. The Constitution is the law that tells us how we get laws. It has a certain logical primacy. And that's what Marshall and Hamilton were trying to explain. But in order to do that, they had to do this as I'm telling you. They had to take people back to say, look, this all comes down to what we mean by a constitution. If we understand it's the ground of the laws, then of course it's going to have supremacy, preeminence over any statute coming later, or else it's no longer a fundamental law that has control on the legislative power.
Professor,
yeah, go on.
If I may jump in, because I think this is something that's really
Ben,
important.
it's your show. It's your show.
We see this tension, obviously, between a strong legislature and a weak judiciary in America. And I want to ask you this, in light of what you're articulating here, what happens when you have laws that of themselves that are made and duly passed by our legislature that are in and of themselves violative of a higher law, God's law, the law of nature? How is the judiciary to react to those? Is it to nullify them? Is the answer nullification? Because I believe you quote Abraham Lincoln in here where he kind of scoffs at the idea of a nullification. Obviously, individual actors are not to follow laws that contradict a higher law. You know, an unjust law is no law at all, as Aquinas says. But what about a judiciary that's tasked, this weak American judiciary, that's tasked with interpreting and applying perhaps wicked positive law?
there's a whole ensemble of questions there, David. Lincoln said, if we respect the ground of the law, we respect the terms on which it was made. It did not come from a dictator, from an elected body. We started with governed by the consent of the governed. You may have to put up with what you think is an unjust law until it can be changed. He said the fugitive slave clause, the obligation to return fugitive slaves. He thought slavery was wrong. But the fugitive slave clause was in the Constitution. He knew we couldn't have the Constitution unless we'd agreed with that. So he was obliged to respect it, okay, until it could be changed. And to live with slavery where it was, he's just trying to restrain its expansion and try to take the steps that would gradually, as he said, put it in the course of extinction. So if you respect the principles that give us, governed by the consent of the governed, then you're going to have to live with some of these things until you could change them legally. Well, the same thing with the court. Look, you had a decision, for example, just came recently, not too long, where we found even liberal judges in case of child custody with mixed racial couples, assigning the child to the white parent on the assumption that the white parent is more likely to be better off, and the kids were more likely to be better off with the white parent. Then it comes dawns on the court that you don't understand what you're off doing here in these matters of family law, right? Family law, the clearest case of local law, family law. What are you doing here with family law? Runs counter to what we understand now as the deep principle of the Constitution, that you may not assign benefits and disabilities to people on the basis of race. You cannot assume on the basis of race that the black parent will be a worse parent, that the children will be better off under the white parent. Now, it then dawns on people that there's a deep principle there. But isn't that the way it works, David? You may have to come to, you may not have recognized at first what was the wrong of slavery. They're getting there bit by bit. But the question is still there. And yes, the court may reach it at a certain point. And the court is a teacher. What has transformed the whole opinion on things like same-sex marriage? Unless the fact that the court was making a strong statement for its rightness. The law is a teacher. When the law, go back to your early example, when the law, before the Civil Rights Act was passed, 1964, 75% of people in the North were in favor of the law, barring racial discrimination, even in private businesses open to transactions with the public. 75 people in the South were opposed to the law. 3 years later, the majorities were parallel. 4% of people in the North as well as the South supported the law. What had happened? Had the culture changed? Did it have something to do with the fact that that act removed that matter of discrimination from the domain of my private choice, my personal taste, and treated it as a matter of moral consequence? It should be forbidden to anyone who's an owner of a private establishment dealing with people this way. That the law was a teacher. The law, it had something to do with the fact that the law at the top of the state was teaching a different moral lesson. Well, that's the way it goes, and sometimes we're slow in picking it up. And look, Lincoln, as Russ Hittinger pointed out, when Lincoln raised his hand on March 4th, 1861, to support the Constitution, he could have been agreeing to support the Dred Scott decision, establishing that it was wrong to dispossess people of their property and slaves when they enter a territory of the United States. He would not treat that decision as though it were part of the Constitution itself woven in. He had just led a national movement to resist and overturn the Dred Scott decision. So because the court said it, did not necessarily make it part of the Constitution. It was open to argument. He led a resistance to it, and gradually, of course, he and his Congress would keep cutting it back until it was finally overthrown with the war and the 13th Amendment. So, again, if we have a decision to make, about the rightful form of governance over human being. It's not a dictator whose edicts are simply to be regarded as law when he says it, but it's a regime of consent with the legislature, with people are forced to give arguments to each other if they're trying to make law, and forced to confront people whose interests may be at odds with the law they're putting in place. That's what we want in principle. Then yes, we're going to have to live for a while with bad decisions and try to correct them and chip away at them when we can, until perhaps the recognition settles upon us that, we had to look. And that
Professor Arkes, I hate to interrupt. We're up against the clock here, and I just want to give you the opportunity to maybe close us out with, if you think there's anything, if you could tell my audience anything that they should take from your book, Mere Natural Law, what would it be? What would be the one takeaway that you really want people to get from this book?
Well, Thomas Jefferson said you could give the same moral problem to a professor and a plowman, and the plowman would be as apt to get it right. He wouldn't be distracted by theories. But the natural law finds its ground in those precepts of common sense that ordinary people understand and readily grasp. Like that point about we don't hold people blameworthy for acts they were powerless to do. There is no ordinary person who doesn't get it. And the point is, the real ground of the law, the natural law, is to be found in those precepts of common sense that were they're in place. They were in place before we had the laws, before we had the Constitution, and they would be there even if there were no Constitution. And they're accessible to ordinary people. You don't need a law degree to understand.
Thank you so much for being on. Thank you for writing the book. The book released on May 2nd, again from Regnery Press. Please pick up a copy. And we hope to talk to you again soon, Professor Arkes.
Okay, David. Thanks so much for having me on.